Well, good afternoon, everyone, and a warm welcome from Stuart's to our expert witness training webinar. This is actually our inaugural session in this format. I'm sorry we can't meet as previously in our office in the flesh for a full day, but we will be running these webinars in this format at more regular intervals, I hope, during the coming months. Today's talks are by a lawyer and a medical expert, and effectively the lawyer will be saying what he would like to have from an expert, and the expert what he would like to have from the lawyer in order to present the evidence. The lawyer is Gerard McDermott, QC, who's been working with us for many years at Stuart's on our catastrophic injury cases. And the medical expert is Mike Hayton, who is a highly reputable hand and wrist surgeon who has an interest in sports injuries and training, and also medico-legal work. If you look at his website, you will see the high profile of sports personalities who say they're lucky to have been patients of his. So we'll have a question and answer session after the two talks. And if you could please use the chat facility to put the questions to us, we'd be most grateful. Before I hand over, I would just like to express to all those of you who've been involved in excuse me, the fighting against the coronavirus pandemic to make us all safe. And with that, I'll hand you over to Mike, I think, who's first on. Thank you.
Great. All right. Thank you very much. And thanks very much for the very kind invitation to speak. Let me just share my screen. Slideshow, there we go. Can you all see that okay? So, well, welcome, and hope everyone's keeping well. It's certainly slightly unusual times. And my brief today is to talk to you about me as a medical legal expert and what I've learned over the last 20 years or so of doing that. And also my interactions with solicitors and people like Gerard, and you know, what I get out of this, what's enjoyment, and what are the downsides as well. So I work here at Wrightington Hospital in the northwest of England, which is an orthopaedic elective hospital, made famous in the 1960s by John Charnley, who developed the low friction hip arthroplasty. I also work in South Manchester at the Orth Team Centre, which is a diagnostic and treatment facility in the grounds of Spire Manchester Hospital, which we opened just over a year ago, and that's proved to be a really enjoyable experience. So what is an expert? You know, that's the first thing that you probably need to address before you start doing medical legal work. You know, are you truly an expert? You know, well, there's lots of definitions out there, but the one I like is it's a specialist, preferably in current practice, although that's not absolutely necessary. If a clinical professor of 40 or 50 years experience is still relevant, I think that would be reasonable. And I think it's reasonable that you're managing the types of cases that you're asking to comment upon and give your opinion on. So you should be relevant, you should be up to date with all the relevant literature. My own expertise is, as Nick mentioned, is in hand and wrist, but I don't do microsurgery. And my particular interest is in sports injuries. And I lecture quite a lot in the UK and overseas. And it seems that everybody in orthopedics is a specialist in sports injuries. But I'm going to now show you the world's first ever sports gastroenterologist. Here he is, taking a close look at one of his competitors. So what is an expert? As we've alluded to, it's somebody who's current, up to date with recent advances, and should have some knowledge about the current literature. I think it's really important that they are truly independent. and it's their opinion, and they should stick with their own opinion, and perhaps not be swayed by external pressures. And they understand that ultimately their responsibility and their duty is to the court. And Gerard will touch on if you stray away from what your fundamental duty is. So really your objective is to assist the court to understand the medical issues around the case. And I always like to use lay terminology wherever possible. Sometimes we can get carried away with medical terminology that just causes an inconvenience for the reader to have to go and look up what that means. So if you can somehow weave in there the medical terminology as well, the lay terminology as well as the medical terminology, well, that's obviously the better. And I do know some people have got a glossary at the end of their medical reports, which can often be quite useful. But as we'll talk, Gerard will mention, we want the medical reports to be as concise as you possibly can. So that glossary should either be on your website or perhaps as an appendix. So the role of the expert is really to establish the nature of the injury and how it presents in this instance. And then once you've established what the diagnosis is, how that injury impacts the individual, both from the time of injury through to the present day, and then how that might interact with that individual with comorbidities. They may have a pre-existing shoulder problem, and they've now got an elbow problem. So how these all interact, you'd be expected to comment, but you'd want to stay within your own area of expertise. So clearly you wouldn't be talking about neurological conditions if you were a hand and wrist surgeon. So you just stay in your own area. But if there are other areas that need comment, you would then recommend a other specialist expert. And then finally, you want to talk about what the long-term prognosis is likely to be for this patient and whether there's going to be any deterioration. You want to talk about how it might affect them on their open labour market and whether they're disabled for the purposes of the Equality Act. And all of these are pretty standard things. So what do we as expert needs from our instructing solicitors? Well, we need a letter of instruction, and it's really helpful for us as clinicians if there's a few key components to be addressed or highlighted, and then we will certainly pay particular attention to addressing those questions. The medical notes, increasingly now, we want them electronically, particularly COVID, that's really brought that to the front. And we don't want all of the notes. If you're a hand and wrist surgeon and the patient's been involved in a serious head injury, I really don't want 6 CDs with their ITU admissions. And I know that's difficult sometimes for someone to paginate and pull them out, but for me to go through 6 or 7 CDs with all the medical notes that aren't relevant to me are obviously going to come at a cost. So it is better if they can all be pulled out. So just the notes relevant to that expert in an ideal world. And then imaging. We historically had hard copies in big X-ray packets. We then went to CDs, and CDs were around for 10, 15 years. But of course, you know, no CD worth its salt comes with a password, or if it does come with a password, it's incorrect. And certainly when you get a correct password, then your software doesn't work on your computer. So increasingly frustrated now with CDs. And we do like them to be electronically transferred. And lots of the hospital providers where people do medical legal work from have got an electronic portal where the imaging can just be transferred from one hospital to another at extremely low cost and very, very quickly. And it's there as a permanent record. And then we do want the other reports that might be relevant to our report. I certainly wouldn't want to see any reports that aren't relevant to me because I just simply wouldn't look at them. And then finally, what we need is a timescale. Oh, I don't know what's happening there. We need a timescale, and we need to know when this report needs to be finalised by, so that we can work to that. But I think most people who've got a proactive medical legal practice usually turn these around reasonably quickly, and I certainly try and get my reports within 10 working days back to whoever has instructed me. What an expert does not need, in my opinion, is a law degree. I remember when I first started out doing medico legal, someone said to me, oh, you should do a law degree. And I think it might have been even Gerard who said to me, you know, you're here as a medical expert. If we wanted you to be a law degree, you'd have to go to law school and go through the appropriate training. So I've certainly stayed away from that. I'm just here to comment on the medical issues, and certainly would leave the legal side to the experts in that field. And we've mentioned already that our duties are to the court, and we should be impartial at all times. And so just a few top tips for experts. Getting started in medico-legal, I think it is important, not just in medico-legal, but generally in life, is try and grab a good mentor. And if you're more senior in your career, perhaps look to mentor someone yourself and help people on. You can either get started doing medico-legal yourself, or occasionally some clinicians will inherit a retiring senior colleague and they can take over their practice. And I would call that the silver spoon practice. I've been doing reports for a long time, and as you get busier with family life and clinical practice and all external pressures on us, and we all know that everybody's busy, I think it's important that you make dedicated time for medico-legal work. It's not really a hobby, and some of my colleagues in the past have seen this as a bit on the side, really. And I think that's probably an error, because it will just conflict you with your external pressures of time. So what I like to do is I do a lot allocated session to do this work, and I see my patients on a Monday morning, and then on a Friday morning I have time set aside to do all my admin and addendums. And I think once you do that, it sort of boxes it off for you, and it becomes a lot easier. Gone are the days of me putting in a patient before my NHS clinic starts, being rushed with that, being rushed with my clinic, seeing someone at lunchtime, seeing someone at night, doing addendums late into the night. I think you should want to get allocated time to do this kind of work, because preparation for all this is really important. Also, you'll have a standard report layout that you like to use yourself. It just makes it a lot easier for you and your secretary. And I think it's really important that you just review that every year or two, because you will see other experts' reports that perhaps will be better than your own. And so you should learn from those, their layouts, their style, and just try and alter your own layout. And then I think also is fees. You should review your fees as your experience grows. And I think that's just that's standard for most professions. So the top tips really are also be prepared. And Gerard will probably talk about some people who perhaps failed in their duty as an expert, and it was due to lack of preparation. And as we all know, that you fail to prepare, you prepare to fail. I think as you get more senior, your reports probably become more concise. The first few years of doing this, you feel as though you want to include every single allergy the patient had, which has probably got no bearing at all on their hand injury. And what I like to do now is I just summarize their medical records into 2 or 3 paragraphs in the body of my report. And then, because we can do screen grabs now of electronic records, they're all contained outside my report in an appendix. So they're there for me to reference if I need to in the future, and also anybody who's reading my report can access them. But certainly, I don't think lawyers want to be wading through 35, 40-page reports of just photocopied medical notes. Really try and be concise, get down to the nitty-gritty of exactly what's happened in this case, and it will certainly make your report a lot more professional. And of course, I keep banging on about this, you've got to be independent. As you know, you've got to give a range of opinion, and you may wish to quote some of the literature, but as we're all aware that often in MSK, literature is of poor quality, and an argument can be argued either way. But there always are some key papers that you should perhaps pay reference to in areas of perhaps controversy. And I like to say this is this double doubt test, and it's not just in medico-legal, it's also in my clinical practice, that if I have an idea that I'm going to do something, or I'm going to let an athlete play at a certain time, or I'm going to fix them in this slightly unusual way, and I sort of doubt what I'm doing, that's fine to doubt yourself once, sleep on it, and then if in the next 24 hours you doubt yourself again, that's a positive double doubt test, and you've really got to question whether you're doing the right thing. So it's fine to question yourself, reflect, is this the right thing to do? But if you doubt yourself twice, then take serious consideration if you're doing the right thing. And that's the same really for medico-legal. If you're asked to do something by an instructing solicitor to change something, you know, really do take care about that. Don't rush into doing it, reflect on it. And if you doubt yourself again, well, then you probably shouldn't be doing it. As we all know now, we're living in this virtual world, and video consultations came out very quickly as soon as lockdown occurred. I've been performing them for quite a long time, really, in my sports sector, because many of my athletes live overseas or around the country, and it's just not feasible for them to come and see me for a post-op consultation with their physiotherapist or their doctor or their agent. And so we've been doing video conferencing for a long time, and they've been very, very safe. And clearly, I'm not going to put my reputation online by a video consultation if I really feel I need hands-on. But often, post-operatively, we can perform this. So I was already ready to go when this lockdown occurred. And of course, there's lots of platforms now with Zoom, Teams, NHS Anywhere. Most of them are secure. So security was the really important thing for us to realize with virtual consultations. And I'm still doing virtual consultations now, even though we've opened up to face-to-face consultations, because I find them really useful. It's a 15-20 minute video consultation with the patient. I take the history, the course of events, ask them various questions. Usually a patient-reported outcome measure has been sent out to them. I can get a handle of what they're doing. I can see what their range of movement is through the video screen. And I can also prepare their medical notes and their imaging in a basic report. And then I've got an examination of the patient, which might be 20 minutes, half an hour, when I can go over the report that I've already done, along with all the relevant documentation, and my examination is a lot more focused. So I actually think we'll find this hybrid world going forward, where a patient will be seen for a virtual consultation and then followed up with an examination several weeks later. And of course, conference calls we've been doing for a long time over the telephone, and I just wonder whether we'll be doing many face-to-face conferences going forward, or whether everything will now be virtual. And finally, you know, what do I like about being an expert? Well, certainly diversity in practice. And, you know, my mentor, Ian Trail, said you've just got to keep your plate spinning. So it's not okay just to have all your eggs in one basket. So I've got a clinical practice in the NHS and in private practice. I work for industry. I've got a sports practice and also medico-legal. And when we suddenly found COVID completely cutting and stopping all our private practice and seriously impacting our capacity now, you know, medico-legal has carried on throughout. So that was a really important thing for me, giving me some diversity. I also like to see quite a lot of pathology when you're doing medico-legal, how it's impacted that individual, because you're seeing the long-term history of the injury. But it's also good to see how your colleagues are practicing around the UK. And it's every week I will sort of pick up a little tip on how somebody's fixed something or how somebody's approached something. So there's lots of upside from being an expert. You know, what I don't like about being an expert, we've discussed that. I don't like heaps and heaps of paper notes, CDs with no password or software that doesn't work. And of course, nobody likes external pressure on your view. And you've really got to stay true to your own view. So for me, it was a very brief talk. I enjoy what I do. I take a pride in my medico-legal work, because at the end of the day, it's your reputation, both your clinical reputation and your medico-legal reputation, that hangs on the quality of your reports. And I really think you need to give it the time that it needs. You just can't rush these sorts of things. If you do rush them, you're not going to prepare, and the wheels will come off. And of course, be true to yourself with the double doubt test.
So, good afternoon, and I'm going to leave Mike to field some questions while I talk to you. So,
yes.
Thanks for inviting me to speak, Nick. I'm Gerard McDermott. I'm a Queen's Counsel. I've been a SOC for 20 years or more. I do a lot of claimant catastrophic injury work. I do more than that, really, but that's the focus of my practice. And I suppose I've worked with experts really since the start of my career 40 years ago. But of course, if you're going to do complex personal injury, you're going to deal with a range of experts, and not just clinical experts. Of course, in my time, I've dealt with reconstruction engineers, general engineers, ship surveyors in a shipping case, economists, microeconomists and macroeconomists when we're dealing with cases abroad and want to see how compensation will translate from one jurisdiction to another and what impact inflation will have as between India and England, for instance, and so on. And I've been privileged to work with some great experts, and it's very much a part of what I do. I'm also very interested in the concept of it. I do quite a lot of lecturing on expert witnesses. And in fact, I love expert witnesses so much, I married one. Well, I married her first, and then she became an expert witness. She realized it was the way to go. I'm not going to try and cover everything in 10 minutes. The focus of my talk, really, and I've looked at the attendance list, and many people who are attending this are experts. And actually, although it's focused on clinical experts, what I've got to say really applies, I think, to any expert in any discipline. And if you go into any division of the High Court, you will find experts giving evidence on the issue that is before the court. Economic experts, meteorology experts. I'm involved in a lot of the Grenfell Tower cases. And so the Grenfell inquiry, which I'm not directly involved in, has fire experts, naturally, construction experts, architects, and so on. And these principles apply to all of them, actually. So I've done some slides, but I didn't want you to be distracted when you could just listen to me. And so we're going to send them out afterwards if you want them. And I'm not going to talk slavishly to my slides, but they are the focus of what I'm going to talk about. So some key points, and Mike has covered some of these. We want expert witnesses who are real experts. We want experts who are up to date in their discipline. We want all experts to realize that what we have them for is to enable us to use their expertise to allow us to run and manage cases. So I do a lot of work for those who suffer a spinal cord injury. And I suppose I've learned quite a lot about that area of clinical practice and the impact on individuals and so on over the years. But I need the experts to give me the view on that individual case. And that's what I'm looking for. I want experts who are well prepared. Most experts are, but sometimes they aren't. I certainly want experts who are going to produce reports that are readable and as concise as possible. And Mike's touched on that. If you're going to present a case to a judge, and that ultimately is where we need to be, one of our tips to experts is always assume that this case will go to trial. And when you write the report, imagine yourself in the witness box being cross-examined by someone who doesn't like your opinion or wants you to offer a different view. How are you going to support it? How well prepared are you? And, are you measured? Is your view a measured view that both sides can see where you're coming from? I want it to be concise. If we go to trial, typically a quantum trial to determine what a case is worth may last between 5 and 8 days in my area of practice. And a judge may only get the papers a day or two if you're lucky before. And a judge may have a limited time to pre-read. So actually, she or he doesn't want to waste time reading the same thing time and time again. What they want to know is what in your discipline you say about this case. And of course, one of the lawyer's jobs is to give them a skeleton argument and a reading list that will enable them to make their way through it. But again, just as you should imagine yourself being cross-examined, imagine the judge the night before, maybe in her or his flat in London, maybe in lodgings around the country, knowing the start in this case, which is important for the claimant and the defendant tomorrow, and maybe worth several £1 million, and they want to get a feel for what the case is about. They don't want unnecessary information. You've got to cover the ground as necessary, of course you have, but I don't need you to recite every report that everyone else has written. Mike makes a good point. Don't send him or don't ask him to read the reports that have nothing to do with what he's giving evidence about. That's, I suppose, a lesson for solicitors, but also, and counsel. but also for experts to focus on what it is they're being asked to report. For instance, if I get a report that is perhaps 100 pages long, before I read it, I know it's longer than it needs to be, almost always. And so when you've written your report, go back to it and think, okay, for my discipline and what I'm reporting on, what do I need to include to show that I'm doing my job properly, to evidence the opinions that I'm going to put forward, and to make this report as useful as I can to the court, and also, of course, both to the party that's instructing you and the party that's going to receive it. And always, and I'll repeat this as often as I can, always be independent, and always remember that your duty is to the court. I know your instructions come from solicitors and that you will see us in conference and you will become part of the case in a sense. But one vital lesson, I think, that will always stand every expert in good stead is be independent. So just following on from the duty to the court, and what do we mean by that? Well, it's the most important thing that we want, actually. We want your expertise, but we want your independent view. We are going to put our case together for our client based on your evidence. And we want to know that it's good evidence, that it's well evidenced, that it's well supported, that it's reasonable, and that people can see it is. And we need it to be reliable. And there's a phrase that comes, I think, probably from a case called the Icarian Reefer that says it must be uninfluenced by the exigencies of litigation. We really, really want your view. We don't want you to reflect our view. We want you to tell us what the position is. And that doesn't mean that we intend it to be an unfriendly situation. You know, we may work closely, and many of the experts that I work with in the field of spinal cord injury, brain injury, and cerebral palsy, I get to know quite well. And I'll be working on several cases at once in some instances. And so, for instance, before the days of Zoom, when the choice was generally in-person or telephone conference, I mean, if you think about it, we tended not to use video conferences. They always went wrong. Why didn't someone tell us about Zoom before we had lockdown? But I was always comfortable dealing with experts who I got to know by telephone because I knew their approach, they knew me, and I could have a sense of how they would approach a matter. I would always prefer to see a new expert in person. And actually, just on that point, I think Zoom is great, and I think it's what we will use largely in the future. Just sometimes I think we will want an in-person conference. I think there are sometimes nuances that need to be explained. And sometimes I want to see other areas where the expert is a little bit tentative about their view from their own experience. And I can sometimes pick that up, I think, probably more face-to-face than I would on a Zoom call. Though, as we've all learned, Zoom is pretty good for this. But what we shouldn't want, and I part company with some other lawyers here, I think, certainly in other seminars I've given, we don't want you to be part of our team. In a sense, you are, of course, and if you went to trial, you would be someone I'd want to talk to in the morning and probably in the evening. And if we got a good result, I hope you'd be pleased with it. But you're not rooting for any result. You're there to give evidence. And I always try, whether I always get it wrong, I always try and refer to an expert as being an expert instructed by the claimant or the defendant. That's a subtle difference between the claimant's expert and the defendant's expert. You're no one's expert but the court's. You're no one's person but yourself. And I think that's really important because the better evidence I get from truly independent experts, the more prospect there is that it will, if not match, it will marry up with the evidence produced by experts instructed by the defendant. So actually, I just want to emphasize that, and labor it perhaps a little, that the value to us is the quality and independence of your view. If you're doing me a care report and it comes out with, let's say, 10 hours care and a sleep-in carer every day, when I might have expected it was going to be 24-hour care and needed waking night care, then I would ask you about it. And I would say, you know, will it cover this? And I will perhaps challenge you a little about it. But ultimately, if that's your view, that's your view. We run cases on the evidence. And the best realistic evidence that I get, the more confident I can be in it, and the more chance there is of reaching a compromise with the other side. And let me just pause to again say some things that are obvious, but I think they're probably worth repeating. Why do we have experts at all? Well, the court is there to make a decision very often as to what a case is worth, sometimes as to whether a defendant is liable at all, whether someone has been partly to blame, whether there's someone else that is in the frame. But very often it will be about valuing. And the only way in which a court can come to a view on valuation is to listen to the different experts. When we see a headline in the papers, you know, claimant wins £10.9 million, of course, first thing many people say is, well, they didn't win it. They did in a sense, they won the case, but it's compensation for a very serious injury that's at that level. But sometimes people say, you know, how do you get to numbers like that? The answer, of course, is we build it on the expert evidence that we get, and that's why it's so important to us. And so you're there to assist the court in areas it has no expertise in. You may have an experienced personal injury judge. You may have a judge who has done a lot of cases of catastrophic injury, who when she or he opens the papers will think, okay, I can see what sort of bracket this case is going to be in. But then to drill down, they are relying absolutely on you. Sometimes, of course, we want an expert also to interpret clinical information. Or in terms of liability in road traffic cases, I might want an expert to interpret what the physical evidence that you've found at the scene of a crash means. Can you deduce the speed that the cars were going at from the evidence that's left, the physical evidence? Can you use skid marks, less often these days, but can you use skid marks to show how the deceleration would translate into a speed at the time that the crash occurred or when someone first saw the hazard again in front of them? And engineering evidence of that kind is all the same. For economic evidence, I may want someone to tell me, and in cases I have required someone to tell me, what is going to happen to the economy in India as opposed to the economy in England if I choose to have periodical payments for care and case management that's going to take place in India, priced in pounds, or priced in rupees for that matter, by an English court. And for that, I need to know what's going to happen to care costs. And they're not going to match the English care costs. They're probably going to accelerate because emerging economies begin to track developed economies. And that's the essence of what I learned about economic evidence in that case. And you're there so that we can present our cases on each side, and so the court can make a decision. But more often, of course, you're there because we want to try and reach a compromise. But from your point of view, you should, as I said at the outset, always assume that every case will go to trial. Always assume that the report that you wrote passes muster, that it looks proper, it's well researched, it's well proofed, it's well set out, it's readable, and someone could read it and say, okay, I understand that aspect of the case now. Well, I understand what the claimant instructed by the expert, the expert instructed by the claimant is saying, certainly, and prepare accordingly. And you know, every lawyer should always remember that when an expert goes into a witness box, they are taking with them their reputation. And it's part of your job to make sure you don't risk it. If you had a consultation with an expert as a barrister, and you asked questions about something, and the expert said, I don't really think that, then that's his evidence, or it's her evidence. Don't go and try and revisit it in the witness box and try and push the expert further than they are comfortable. That's not the deal they signed up to. They signed up to giving expert evidence. Not evidence that simply supports your case, simply expert evidence. And because it's your reputation as an expert, it has to be your view. So what rules are there? Well, you know the rules. So do I. But actually last night I dipped into them again. And I think this isn't an introduction to expert evidence. It's really what lawyers want. But you know, it does no harm to go back to the rules. And of course you get the clinical notes and you see the claimant and you write the report. Maybe once every 3 or 4 months, it wouldn't do any harm to go back to CPR 35, always online, read the practice direction, and crucially from an expert's point of view, read the Civil Justice Council guidance, what we expect from experts. And it's useful. I looked at it last night. You think I'm going to reach for it and read it to you now. I'm not. You're okay. We haven't got time. And you'd fall asleep if I did. Much better done by yourself. Perhaps in the evening, perhaps with a glass of wine or whiskey at the side of your desk when you do it. But do it. It really is helpful to you. It'll tell you what's expected. It reminds you of what the court is looking for. And regular reminders to yourself, as with lawyers, may help when preparing your reports and when you're dealing with questions. If you're asked questions by the opposing side, have a quick look at what the guidance says. Have a look at what the rules say. If you're in any doubt, ask your solicitors what's required from you. It's part of keeping current. So I've just seen something come up on the chat box. Let's see if I can deal with it. Can I give some insights into cross-examining expert witnesses and how it all differs from standard cross-examinations? Okay, well, let me just break into it and deal with that. Cross-examination of anyone is always about being prepared. Preparation, preparation, and preparation. I will never forget, as a young barrister, cross-examining a very wily orthopedic expert called David Markham in Manchester, who was terrific. He did a load of expert evidence. He was obviously a good clinician, and he was a real gent. But my orthopedic expert had to go off and do something, and David could see as I was cross-examining him that he disappeared. And of course, not wrongly, slightly mischievously, he began to tie me in knots a little bit. So in that instance, I actually needed my expert there to deal with any points that came up. But also I learned the importance, probably from that, of being prepared, of knowing exactly what everyone had said. And when I'm dealing with an expert, you need to know the case better than them. I'm never going to know more about wrist surgery than Mike Hayton. I'm not. Even if I start now and work for 20 years, I'm not going to know more. But I do have time to read all the papers, and I might have a bit more time to go probing through all the clinical reports, and I might have time to make sure, well, I will have time to make sure I know the essence of what happened. And if there is a disagreement as to causation or prognosis, I will know exactly what my expert says. So I need to know it better than him. I always think about a case that I did where I appeared against a policeman in a tachograph fraud. I represented a farmer who, in the days of mechanical tachographs, put a wire across, and he was able to make it look as though his lorries weren't travelling as far in the permitted driving hours as they were. And he was tailed for 2 years by a police constable, P.C. Burton, never forgotten it. P.C. Burton knew every corner that every one of these 11 trucks had turned. There was no way I was ever going to get on top of the detail better than him. And I had 2 trials against him because he had a retrial. And I just decided, however much work I did, I was never going to be able to better the detail that he had. But I could better him on the law. And in the retrial, I focused on the law. So I suppose in a sense, I was looking for a weak spot. And in that instance, it was that I had a better knowledge of the law than he had. For cross-examining experts, well, first of all, is to know everything about the case. I think be respectful. You know, I've seen, not so long ago, in a very hotly contested case, my opponent launched into someone who had been a joint expert and I'd then adopted him in the most extraordinary way, and tried to demean him and accused him of being partisan and so on. And I just didn't understand this at all. And it didn't work. I have in front of me, with most experts, whether clinical or otherwise, people who have come to help. They are being paid, but they know their duty is to the court and they're trying to eliminate us. And there is no need for cross-examination to be cross. And unless you think they have crossed the line, in which event, by all means, toughen up the cross-examination. But really, cross-examination shouldn't be cross. And what I'm looking for from experts is, I want straight answers. Again, I can think of an eminent neurosurgeon who I cross-examined on a point, and he knew he knew it wasn't going to help his client's case, but I knew he knew what the answer was. And I asked him twice before lunch the same question, and he didn't answer it. And so over lunch, I just typed it out and I handed it up and said, I've written it out. Can you answer it now? And so actually, you staying polite with a smile on my face. The deal is, of course, that experts respond appropriately to questions that are being asked of them. And if they don't, the judge will pick it up, and it won't help the side who have called him or her, nor will it help his reputation. And if you look at 3 or 4 judgments, you can see the way that judges just won't stand for people who have become either partisan or obtuse or just aren't properly prepared. So sorry, I diverted a little bit, but I wanted to make this interactive as far as I can. Fantastically helpful, thank you so much. Well, that's very good. Thank you very much, Mr. Fummel. What do we expect you to know? Well, I want your expertise. I want up-to-date expertise. For medical experts, I want to know you're up-to-date with developments and guidelines in your field. So not so much a wrist surgeon like Mike, but imagine I've got a shoulder surgeon. And in fact, I think we may have one watching. And if I am calling you to deal with the impact of 10 years of wheelchair use, of a manual wheelchair, of a mid-thoracic paraplegic, I'd really like to know what the incidence is. And I know it won't be precise, but I'll bet there are papers out there. And it would help me to know that you've got papers to back up your view, and I'd like practical expertise and so on. And that's, one of the things that I like as well. And I'm just going to pause a moment because I've just noticed a little chat from Waggy El Masri. I have done spinal cord injury work for over 30 years, and I want to pay tribute to Waggy El Masri because he and Krish Krishnan really started me understanding about spinal cord injury because they were experts. And of course, I was then fortunate to be tutored as well by the late Brian Gardner. And I suppose I mention that in the context of experts because each of them, independent experts, interested in the field, interested, I think, in the role that they play in litigation, but always independent. If I have a care expert, I don't expect you to know everything about the legislation that governs the provision of care, but I do expect you to know about the Care Quality Commission. I do expect you to know at least a little about the working time regulations and how that impacts on the delivery of care. I probably want you to know a little about manual handling. I'll certainly want you to know and have a view in a clinical perspective on when hoisting may be required and why, and whether it needs 1 or 2. If you produce a rate of pay for carers in West London or East London or Northamptonshire or whatever, I'd like to know that you've researched it, that you've either market tested it or you've called agencies in the area if it's agency care that you're using, because the battleground in care will be a number of things. It will be the number of hours. It will be sometimes a level of care, though typically not typically, but it'll be the rate. And actually, I'd like that to be done. And sometimes for people who work for some of the bigger care agencies, it's been said, well, this is what the office says. Well, I understand that there's centralized research and that's fine, but the person who's giving evidence is you. So you need to be comfortable in those rates. You need to know how they've been derived. And if they look unusual to you compared to what you may have used when you were with a different company or whatever, then understand why. Because if you're on the sharp end of either me, if you're reporting for a defendant or for the defendant's sake, we'll want to know. And we will be determined about it. I hope we'll be polite, but we'll be determined. And actually, you'll find that First Injury Silk know quite a lot about care rates and how care should be delivered and so on. I want to know about the particular issues that arise in care regimes. I'd want someone who's reporting a spinal cord injury case to understand the potential impact of pressure areas and spinal cord injury and so on. And Mike's just reminded me, if you're asked to give a report, care expert, clinician or whatever, if you feel it's straying out of your area, if you think actually, you know what, this is such a difficult case, I really want to view on a tissue viability nurse, then say so. Mike's double doubt test. It's not always possible. If you were dealing with a case worth £20,000, we can't afford to have an expert. If you're dealing with a case worth £10 million where you think there's a need for more expertise, tell us, because it's proportionate. What do we want in your report? Well, we want details of your expertise. I don't actually need to know every paper you've ever delivered. And actually, it's not necessarily helpful to me to know that you've been to 3 courses run by barristers' chambers on expert witnesses in the last 4 years. I mean, it's helpful, and I'm glad you come. And it's okay to put it down, but I'm not looking for that. I'm looking for what your experience is. Have you worked in the community? Have you worked on a critical care ward? Have you worked in a spinal injury unit? Will your general nursing expertise be sufficient to ground you in that? And that's nursing. If you're a surgeon, of course, I want to see that you're a surgeon who specialises in this area. And Mike, it seems to me that the last 20 years in particular, orthopaedic surgeons have become much more specialist. We used to sometimes think of, well, I used to think of orthopaedic surgeons, and I can think that when I first came to the bar, if you want an orthopaedic surgeon, you go to Peter Frank in Manchester, he'd report on most things. But you wouldn't report on lower limbs, really, would you know?
No. And I think experts should just report on what their clinical practice is on a regular basis. I think that's a reasonable way. And there are some orthopedic surgeons who are still general and will do hips as well as ankles and knees, and as long as they're doing it regularly and they're relevant, then that's fine. They may not be the person I choose to go to my ankle if they're mainly a hip surgeon, but I think it's if someone's doing something regularly, they're relevant. I think that's fine.
Okay. So I don't also want every last detail from the start. I don't need every medical note dictated from the file. Please, please don't do that. I don't need every witness statement digested. I've read them and the court's got them. I don't really need a commentary of what others have said. If you do want to do it, and I can see you might want to do it, then put it into an appendix so we can see one, you've referenced it, and sometimes it will be a very helpful reference for us as well. But if a judge is, and I'm thinking particularly of a judge, if a judge is wading through a 50-page report and finds that 30 pages notes, as Mike says, it clogs up the point that we want you to deal with. I don't necessarily need a detailed analysis of the model of nursing or care, though I do want to know why you're saying agency. I do want to know why you're saying living care and so on. The one exception to that, I think, is this. I think particularly of spinal cord injury, but I think it probably applies to serious brain injury as well, but spinal cord injury, I think it's very helpful to any lawyer and to a court dealing with a spinal cord injury case when dealing with quantum. We all know there will be one key report, and that will be the spinal rehabilitation expert. And that will guide nearly everything else that's done. And in that instance, and to me, the best medical reporter that was in that field, or one of the best, remembering that Waggy's on the line, but one of the best was Brian Gardner. And I knew I could pick his reporter, but I know most about the case by the end of it. And it was my guide to what else I needed. There are a number of newer reporters going on in that field. And I've recently had one where it did have screenshots of the treatment. And actually, I found that very helpful to see the course that my client ran from initial trauma through rehabilitation to discharge, and to see how the problems developed and were managed. That was very helpful, but it was also relevant. But generally, I think you can try and keep them a bit more concise. So what don't we want? You'll gather, and this is a personal lecture, other people might say differently. We don't want overly long reports. I certainly don't want reports that don't have any order to them. I don't want reports that are badly spaced. I actually, and it's surprising that we still have to do it, I actually don't want a report that's not properly put together. It is a matter of regret that sometimes I do find that we have to send detailed requests to absolutely reformat a report because they just can't follow it. It's rare, but we will not hesitate to say, actually, this is not really going to read well. And I've got, I can think of a number of instances where I've had to do that. And sometimes it's because they've taken on too much work. And that goes back to Mike's point. Allocate yourself time and probably don't take on more than you can manage. I don't like reports that don't identify the issues. I don't like the ones that don't identify the basis for a view if there's a controversy about something. I don't like reports that don't properly identify the cost. And again, it's rare, but on occasions I've really had to look at the costings and say, where are these from? Because they're plainly out of kilter. And that's really the centre of many reports. We want a report that covers the ground. We want it to be concise as possible, but full enough to deal with the issues. And I'm not saying don't put detail in. I am saying when you get to the end of a report, if it's more than, say, 30 pages, ordinarily spaced, have a look and think, can I cut this down without losing the impact of what I want to say? I'd like a report that's properly proofread. To be frank, medical reports can be quite expensive. And I understand that you're going to get typos and everything. Ask any solicitor who's ever read any of my advices, however many times you do it. But I don't expect to find 6 or 7 non sequiturs on the same page. And I think that's really important. It's important for your reputation. It's important to know that you presented it properly. I'd like to have page numbers. I'd like to know that the arithmetic is correct. And I'd like it to be supported by papers where you think appropriate. Importantly, we always remember that you are not advocates. You are not pushing for one result or another. But you do have an audience, and the audience is the parties and the court. And actually, particularly in claimant work, some claimants, not unnaturally, have been through a lot. And they can be a bit sensitive about finding that their name has been misspelled all the way through. I know it's a small point and it's easily done, but to them it's really important. So I want it to be independent, I want it to be clear, I want it to be well reasoned, well ordered. I want it to reflect your expertise in the area and have an opinion. And so what about your interactions with lawyers? Quite often you will be invited to conferences. Thankfully, as we all know, now they will be Zoom conferences. I think one of the benefits to many lawyers and experts, probably, particularly if they live distant from London, but actually depending on where you are, wherever you are, it means we've spent a little less time on the train. I find I'm not coming in at 9:30 off the train. I think experts feel the same. We can fit conferences in more readily and they can be managed more readily. We want them because we want to understand the case. I can read a report and think, okay, I think I've got that, but I want to just see the surgeon, the urologist, to understand that I really have got this, so that when I come to present it to the court, I'll argue it with the other side. I know what I'm saying. On occasions, we will ask you to probe, we will ask you to reconsider, but they should always be requests. And we may ask you to consider the expert views of others, but I am absolutely clear we should never exert pressure. Cases are decided on the evidence. And as a junior, a long time ago, I saw some leaders sort of say to the experts, could you just say? And I'm thinking, I'm sure that's not right. And I hope I never do it. I might ask an expert witness to say, does that follow? Or would you be prepared to reconsider it? But the last thing I always say to an expert, and if I ever draft an expert's letter, it will always have at the end of it, at the end of the day, this is your report and you must be entirely comfortable with it. I can think of a conference I once had with an expert, and we were probing various scenarios that might have happened and given rise to the accident. And that was legitimate because it wasn't plain. And he said, actually, I think that's right. I agree that's the case. And we got a letter 2 or 3 days later, which is great in a sense, because he said, actually, I thought about it again. And Gerard McDermott said, unless you're sure, I don't want you to say it. And actually, I'm not sure. I was quite seduced by the lines that were being put, but that's not my view. And that's great. I know where I am, and I absolutely know that expert is independent. And I think that's the one advice I would always give to any expert. As you send a report out that's going to be served, are you happy with it? Are you comfortable with it? Are you happy to stand by it? And are you happy to respond to questions about it? Equally, if the underlying evidence changes, you may need to say, actually, this is a different clinical picture now because of this intervention. So in terms of what lawyers should do, it seems to me that they should always remember that this is your report. And when you get on a slide, you'll see in headlines, this is your report. It's okay for us to ask about content. It's okay to ask about other things that you might take into account. But if you always stick to your independence and your duty to the court, and you don't hesitate to say, actually, that's not my view, that's good for you and it's good for us. The case is worth what the evidence says it's worth. And you'll see I put in my witness statement, the witness box can be a solitary place and your reputation is at stake, not the lawyer's. And of course, my job sometimes is to make the witness box a somewhat solitary place, and it's part of what we do. Deliberately in a sense, not with any intent to make people feel uncomfortable. But there we are. As I say, you're not advocates, you're not part of a team. We want you to consider all the arguments, including those of the opposing party. And that leads me really onto joint statements. These are vitally important. They need preparation, they need thought, they need protected time. Actually, although, if I think I've got a case that's running swimmingly and someone goes into an expert witness joint statement process, I think, well, okay, I hope that's going to be the case that it comes out. But whatever comes out, it's helping us resolve the case. And if an expert witness says, actually, on reflection, I thought it didn't really need 2 waking night carers. It only needs 1, or it only needs sleeping care. That's okay. It's not reduced the value of the claim that I'm running. It has reduced the prospects, or it may have increased the prospects of compromising it. And if that's the evidence, that's the evidence. But the one thing I would invite experts to think about is that you really need preparation time and thought. And again, the point from Mike really, protected time, so that you can consider the opposing evidence and make sure that they are for experts, not for lawyers. I am not a fan of long agendas. I may want to put down sometimes 6 or 7 points. I have seen agendas of 52 questions with sub-questions. Well, my very strong view is this is not about cross-examination. It's about seeing where there's a meeting of minds. I've got a few more minutes, haven't I think, Nick? So what if it goes to trial? Well, first of all, I've always said, if you're doing an expert report, assume it's going to go to trial. If you go to trial, be prepared. Be in command of the notes and your notes. And actually, just on that point, if you are taking notes when you're examining someone and you keep those notes, they aren't often asked for, but actually they're probably disclosable as part of your expert evidence. Listen to the question. Always remember the duty to the court. And if you've approached reporting your evidence in the right way, there should be no concerns. But sometimes it goes wrong, and it can go wrong. And increasingly, the cases over the last 7 or 8 years have shown that when it goes wrong, that may spell difficulty for an expert. When does it go wrong? Well, often when someone isn't well prepared, or they haven't addressed the issues fully. Sometimes when they've altered the view without any obvious reason for doing it. And that's why I say, even if something seems reasonable when you're talking about it with counsel at conference, always reflect. And if actually you say, yeah, I know I came to that view on consultation, but actually I just don't think it sales. And actually that's not what I'm going to say. It's your job to do that. So examples of things going wrong. Well, you'll find this in the slides, but about 7 or 8 years ago, I did a case about a motorcyclist on the A4 driving past the Sky Studios, and someone pulled across her. And the case was all about speed and avoidability and so on. And my expert witness said, I really haven't got enough information to reconstruct it properly, but here's some of the pointers. The other side's expert said, well, this is what happened and this is what the speeds were. A number of things transpired in his cross-examination. He'd never been to the site, although he drove past it quite often. He'd never taken his own measurements. He'd used Google Maps. He'd used Google Pictures. And when he'd come to do his calculations, he'd used a spreadsheet that ran through his report. And he made one error in his spreadsheet that then carried through. But it was worse than that. He didn't really want to acknowledge the error. And we'd only gone to trial on contributory negligence, and we'd only gone to trial because of his report. I would have conceded something, but didn't, and we went to trial, which was very expensive. It was in the days when there was 100% uplift if you went to trial on fees. And it turned out that actually he'd made errors. And so I think he started off saying we were traveling at about 53 or 54 miles an hour. Within 10 minutes of cross-examination, we got down to 51. Then we got it down to about 49. And I can see now the judge, Mrs. Justice Carr, terrific judge. I would say that she found for me, but saying, how far do you live from court? And the expert gave the answer. When you get home tonight, could you highlight in red in your report and do me an amended report, identifying where you've had to change your evidence because of Mr. McDermott's questioning? He didn't respond to questioning very well. I said, have you got a calculator? No. I said, well, why are you coming to court in a case like this without a calculator? And so he said he'd do that, and he brought it back the morning after. Unfortunately, overnight, we'd found some more errors. And so I said, thanks. It's still not right, is it? And he hadn't taken care of it. He'd not checked it. And when I challenged him, he didn't say, actually, I've got it wrong. Can I have 20 minutes? He persevered. And you'll find this quotation in the papers I'm going to send you. And it's the judge reciting my cross-examination, which goes, you are much less confident in your conclusions than 2 days ago, aren't you? Yes. You're less confident than when you went in the witness box this morning? Yes. They're not reliable conclusions, are they? No. So I won. He was criticised, and it was a bad outcome. And case references in the papers, you can find it for yourself if you want. But other possible outcomes, if a defendant or a claimant for that loses an action and they have to pay extra damages or costs because of an expert witness, I think there is every reason to think that they will look to the expert witness for damages, for the costs of the trial and so on. And as I understand it, that sometimes happens. There's a once eminent spinal surgeon who's a very nice man, actually. He had all sorts of difficulties, and he gave evidence that proved to be not up to scratch. And a case was run to trial on the basis of it, as a result of which the NHS Trust asked personally against him for an order for costs. And they got an order for costs of £90,000. I don't know whether he was insured for it or not, but that's a realistic outcome. And of course, it's damage to reputation. There's another case of Harrison Johnston, a 2016 case where an eminent neurosurgeon really just misread lots of things and didn't look at where he'd gone wrong and got very seriously criticised. So that's the downside. The upside, of course, is, as Mike says, that many of you enjoy it. It can provide a very good profession. We rely on it, and we like working with you. When I say you're not part of a team, in a sense, of course, I know you are, but you're not on my team. You're there to give evidence to the court. So that's really the things I have to say. Nick, why don't I just take a look at what chat's come up and let's see what there is. Okay, so occasionally an expert is asked to give an opinion on something that's not strict within their sphere of expertise. How is it best to respond to that, especially if the expert has a view on the correct answer? I think the answer is it may depend on how you're asked. I mean, frankly, if I were doing cases worth £50,000 and I brought Mike in as a fractured wrist and he was dealing with it, and there was an issue on the elbow, I might say to him in conference, what do you think about the elbow? And he might give me a provisional view. I wouldn't ask him to opine on it. I'd say, do you think it merits a different expert? I suppose there might be circumstances in which I might say, look, it's not worth a lot. Would you be, well, you might can give me the answer. If I said to you, would you be prepared to write a letter saying this isn't directly my sphere of expertise? Would it depend on whether it was a general orthopedic principle or whether it was a nuance of elbow surgery, Mike? You're muted.
Sorry, say that again. It was
If I was dealing with a risk case with you and it wasn't very valuable and I didn't really want to go to another upper limb surgeon and I wanted a view on something that might make a difference of £10,000 in damages. Would you ever give a qualified view, saying, you know, I've been asked to give a view on this. It's not what I do day in, day out, but I'm conscious that another report might be disproportionate. Would it depend on the intricacy of the issue I was trying to deal with?
Yeah, sorry. Yeah, I wouldn't give an opinion really if it was outside my area of expertise. I think
Okay.
off the record, I would guide someone, but I think officially I wouldn't give an opinion outside my area of expertise.
And that's what we're saying. Don't go outside your sphere of expertise. So I think that maybe is the answer to that question. Let's look at what other questions there are.
There's another one.
Okay, so someone said, as experts are required to prepare for joint expert meetings, it's helpful to have the agenda in good time. I agree with that. I should re-emphasize, I am not a fan of agendas at all. I'm certainly not a fan of detailed agendas. I think experienced medical legal experts can see where the issues are. If I do an agenda, it will typically be 5 or 6 questions. And so I take the point, it is good if we can get them to you sooner rather than later, because then you can think about it. Mike, I don't know whether you have a view on whether you like agendas or not, or whether you need them.
I do like agendas. I think it just forms a framework. Yeah, we all understand the big headlines, but there are sometimes some nuances, and I think they are helpful because you will address them specifically. It saves us having to go back.
In clinical negligence cases, they're crucial where issues of breach of duty and causation are massively controversial. And unfortunately, it becomes a battleground between the solicitors and the legal teams on each side. Exact framing of the questions which you want to put, and I'm afraid sometimes it results in too lots of agendas being put forward from each camp, and it is very unsatisfactory. And I think Mrs. Justice Yap tried to exalt.
I think that's right.
Rethink.
You end up in a battle of agendas, don't you, Nick, if you're not careful?
Yeah.
But that's why I like to keep them simple. And in one occasion, someone sent me a huge agenda. I said, "I'm sorry, I'm just not going to use it." And it was sent to me 2 days before the meeting to see if I'd agree it. And I said, no, you want an agenda? Here's 6 questions. There were 52. Someone's asked, what goes through a barrister's mind when an expert provides a clear opinion that suggests their client's case is weak in terms of causation? What are the options from salvaging the case from the legal point of view, and at what stage do you pick another expert? Well, if it was a big high-value claim and the issue was, I don't know, let's say causation on a Cowder Equiner case, I'd probably first say, well, can we have a con with the expert to see why they're coming to this view? And I will look at the notes, not with the expert clinical view that the expert has looked at them with, but with the view that I know the judge will have and where we'll get to, and I'll want to talk the expert through it. And I will, and now that's a circumstance in which I'll say to the expert, well, shouldn't an MRI have been done the night before? And they may say, well, busy district general hospital, just not going to happen. I said, okay, but in clinical terms, should it have been? And then we will explore together to see whether the expert is prepared to take on board other things. Maybe they will not change the view, which is fine. Maybe they'll have a qualified view. At what stage do you pick another expert? Well, sometimes, if I'm satisfied having spoken to the expert that there's nothing we can do, I'll just say to the claimant, you know what? We've done the best we can. We're doing this on no win, no fee. We've spent a lot of money on evidence. And the fact is, the evidence says you've got no case. In a very high value case, I might say, okay, well, let's just go and see what someone else says before we finally abandon it. And sometimes, there are nuances of understanding and so on that people will use. So that's when I might pick another expert. I don't often go and choose different experts. The same questioner said, I've never been on a Bond Solon course or signed up to the MEWA, which I think is the Expert Witness Association. On the ground, I'll leave that to the law to the lawyers. Well, I think you can leave the law to the lawyers, though actually you do need to know a little bit about the law. I think if you're doing a clinical negligence case, you need to know that the basic Boland test is, did this person fall below the standard you might expect that would be followed by a responsible body of medical opinion? Rephrase that a little bit. Someone would critique that if they listened to it. And I do need you to know that. I don't want you to say it wasn't very well done. I want to know was this choice of approach in this operation something that you can see a recognised body of medical opinion doing? And they said, yes. Was this risk that supervened and caused paralysis a recognised risk? Yes. And at that stage, unless there's been some issues on consent, I just may have no case, and that's the end of it. What we require is clinical responsibility, and that's what people are doing. But on Solon, well, a lot of the expert witness companies do these courses. It will depend on who's giving the course. For my part, I would look out for many seminars of this kind when there are experienced doctors, experienced sisters, and experienced silks giving their view, because actually it's what we do day in, day out, or certainly month in, month out, because we don't do a trial every day. Couldn't see any more questions from that, as far as I can see. But someone said, great webinar, thanks, all. Thank you very much. Mike, do you have any comments on those sort of things? I think second opinions, they're quite rare. Nick, well, ask Nick as well, because Nick would do some in clinical negligence.
Yeah, you have to look at the report. If the report stands up, logically, it holds water. There's nothing you can really criticise about it. He's not trying to go out of his field, or she's not trying to go out of her field. It's difficult to argue with it. You might not like it, but it's only in an area of very high controversy, worth of fantastic amounts of money, that you would think about maybe getting a second opinion. But if the original report is reasonably holds water, then there's not terribly much you can do about it.
I mean, one question here is, on my experience, experts will often mould the answers to the agenda to try and focus on issues that they've identified. Does this irritate lawyers? Well, Mike, if you sat down with a wrist surgeon, I suspect you would both have a view on what the key issues were in the case.
Yeah.
And certain that in some instances, agendas can get in the way. So I would never have suggested an agenda to Brian Gardner and Tony Tromans when they were meeting together. They knew the territory. They knew what issues we wanted to deal with. I mean, as Mike said, I think sometimes it can be helpful. And maybe after today and listening to the feedback we're getting, maybe I should do more agendas. I can tell you from a barrister's point of view, agendas in a difficult case. You look at it and think that may be a day's work, because you've got to understand the case to draw the agenda. So it can add to the costs considerably, but equally, I think you're not thinking about 6-page agendas, are you, Mike? But you're thinking about some key points.
Yeah, I mean, there's obviously the headlines that need covering, where we agree and we disagree, and employment and risk of degenerate change, all that kind of stuff. But there are just a few things that the lawyer just wants clarifying. I think it does help us just address that, at the time, sort of almost this get it right first time for a joint report.
Well, that's my takeaway, that maybe doctors like agendas more than we think they do. So, Nick, that's really, I think, all that I would want to say today. I can see we're about 3:15, which is your sort of end time. Is there anything else anyone you want Nick, Mike, or I to deal with?
There's a couple of chats. I don't know if we dealt with them already. Yes, I think we've dealt with them. So, well, if I would like to thank, on behalf of Stuart's and the rest of us, Gerard and Mike, thank you very much indeed for a really enlightening, really interesting set of talks. And I'd like to thank everyone for joining us today, and I hope we see you again soon in the not too distant future at another similar occasion. And in the meantime, I hope you'll manage to keep safe, and thank you very much.
Well, thanks, Nick, and thanks for inviting me to present with Mike, who I'd like to have on my team anytime, of course.
Likewise. Thanks very much for the kind invitation.
Okay, cheers.
Thanks.
Cheerio.
Right. Bye, everyone. Cheers. Bye.